Hi, this is Joe from PrepAgent, and today we're ready to go over laws of agency. Let's see who's here today. If you're here and you're ready to go, give me a thumbs up in the chat window to the right, and we'll get started. All right, Samantha's ready to go. So let's get going. Okay, first question of the day. A real estate broker should regard herself as A, legal advisor, B, substitute for an attorney, C, fiduciary, or D, none of these. Okay, and a good way to start off the day. And the answer is C. We're going to talk a lot about fiduciary today. That's something we're going to go over a bit. I'm going to ask you a question right now, and I'm going to ask it again later. So let's try it right now. What is the essential elements of an agency relationship? What is the essential elements of an agency relationship? So there's an acronym, ACOLD. ACOLD. Okay, and what that stands for is accountability, confidentiality, obedience, loyalty, and disclosure. So we got to know that. So when I ask that again later, when I ask it again later, I want you to write it in the chat window, that answer. Okay, moving right along to the next question. When a written agreement spells out the responsibilities of the principal and the agent, the relationship created is called A, a limited partnership, B, an ostensible agency, C, an implied agency, or D, an expressed agency. What do you think? Okay, and the answer to this one would be an express agency. Oh, good. Okay, when the agreement spells out the responsibilities of the principal and the agent, it's created an express agency. An ostensible and implied agency is more an actions, an agency created by your actions. It's implied by what you're doing that you're an agency. Okay, but when it's written out, it's an express agency. The implied agency is one of those where I'm acting for it and you're okay with it. Like if I put a for sale sign in your front yard and you're okay with it, then I'm your agent, even though we haven't written anything out. What happens if the agent has not located a buyer by the end of the listing period? A, the broker can sue for reimbursement of marketing expenses. B, the agency relationship terminates. C, the listing price is reduced by 7.5%. D, the listing is automatically extended for an additional 90 days. Okay, and the answer is B, the agency relationship terminates. Here's a question for you guys though. What if what happens if by the end of the listing period, the agent has not closed the deal with the client, but they found a buyer during the term of the listing that wants to close the deal after the listing terminates. I'll ask that again so it's a little more clear. What happens if an agent finds a buyer before the listing terminates, but they did not close the deal before the listing terminates, and their buyer wants to close the deal like the day after the listing terminates? What could be done in that situation? Ooh, nice job, Samantha. The safety clause. Okay, it's also known as the protection period clause. So that's a time to close deals with buyers you've been working with during the term of the listing. It's not a time to find a new buyer. Great job, Samantha. A representative with full authority to bind the principal to all agreements is A, special agent, B, a double agent, C, an accidental agent, or D, a general agent. Okay, and the answer here would be D. Nice job, Allison. Okay, when you see the word all, it's general. A special agent does a specific act. When you're a real estate agent, you're doing a specific act. You're finding a buyer, that's it. A double agent, I think that's from like James Bond or something. Doesn't apply to us. The fiduciary duty of full disclosure requires the seller agent to A, tell the principal anything that would be of use in negotiations, B, advertise listed property frequently, C, obey all the seller's lawful instructions, D, advise the buyer about how much the seller is likely to accept for the property. Okay, and the answer here, tell the principal anything that would be used in the negotiations. Okay, remember, the fiduciary duty, you have loyalty, right? You have to obey their instructions, okay, but you also have to tell them anything that will help them. The agent is obligated to pass on to the principal any useful information that is learned during the transaction. Okay, something that's confusing here. All right, when you have your listing, you don't have buyer's agent and selling agent. You have listing agent, and then you have seller's agent. Seller is representing the buyer. We'll go over that one again. Don't worry about it. A real estate licensee is usually presumed to be the agent of the A, buyer, B, party paying the commission, C, party with whom a written contract has been signed, D, owner of the real estate. Okay, and the answer here, party with whom a written contract has been signed. Okay, not much explaining there, kind of is what it is. When an agency relationship ends, which of the following duties does not continue? A, accounting for the property, B, confidentiality, C, loyalty, or D, accounting for money. So which one of these does not continue? Okay, and the answer here is loyalty. Loyalty you can only have with a specific person, and it does not continue because you have other clients. And your former client may be in the transaction with your new client, and you can only have loyalty to one person. But you still owe that former client confidentiality. You got to be able to tell them where the money is, and you got to be able to account for things that happen with the property during your time working for them. But loyalty only goes with the person you're working with at that time. Now, it does not mean you're not honest with them. Still, you owe everybody honest and good faith. Jones agrees to represent Brown in the sale of a property. The listing contract states that Jones will receive a fee of $25,000 from Brown at closing. Regardless of the sales price, is this a valid form of compensation? A, yes, the broker is supposed to charge that, what the traffic will bear. B, no, a flat fee exposes the seller to being cheated. D, yes, compensation can be determined in any number of ways as long as the seller and broker agree. Or D, no, the seller should pay on the basis of a stated percentage of contract price. Okay, the answer is C. I can pay you with a cookie if I want. All right, whatever's agreed upon between the two people. Okay, so as long as it's agreed between the two parties, whatever it may be, that's what you're going to go with. So Allison asked me if this is a net listing. We're actually going to do a question about net listing coming up that I've saved for us to do. So hold that thought. But just real quick, net listing is an amount above and beyond a designated price. That question alluded to just a designated price, period. It had nothing to do with the sale of the price of the house. So it's different if I sell a property for $500,000, okay, and I say I'm getting paid $25,000, period, rather than if I sell it for $525,000 and I get $25,000 because it's above and beyond the $500,000 initial price. But we'll go over that a little bit more in a little bit. Okay, non-disclosure of a dual agency by a broker can result in A, a loss of commission only, B, rescission of a contract only, C, there is no penalty for not disclosing a dual agency, D, a loss of commission and rescission of a contract. Okay, the answer here is D. Now, depending what state you're in, there's different rules on whether dual agencies are allowed. Some are okay with them, some are not. However, there is no state where it's okay not to disclose the dual agency. Whether it's allowed or not, there's no state, even the ones that allow with them and are okay with it, can you keep it secret. It always must be disclosed. Okay? So non-disclosure of a dual agency by a broker can result in lost commission and rescission of the contract. In some places, there are even additional penalties to that. Once an agency relationship is ended, any confidential information learned by the agent during the relationship is A, still confidential, B, a part of the MLS historical database, C, considered to be used for blackmail, D, shared with future clients. If any of you circle C, just stop studying and don't bother getting your real estate license. So I'll give you that hint. All right, but luckily none of you guys circled C. Looks like you all went with A. Nice job, guys. It's still confidential. It's always confidential. But remember, it does not necessarily mean you owe them all loyalty. Okay. In a real estate transaction, fiduciary duties are owed to the A, principal, B, broker, C, customer, D, agent. What do you guys think? Where is your fiduciary duty owed? And the answer is principal. When you guys study this section about agency, you're going to hear the word fiduciary a lot. Okay. And that basically means you're putting that person's interest above and beyond your own. Okay. And that does not happen with a broker, customer, and agent. The fiduciary duty of full disclosure requires the seller's agent to A, obey all the seller's lawful instructions, B, advertise listed property frequently, C, advise the buyer about how much the seller is likely to accept for the property, D, tell the principal anything that would be of use in negotiations. Okay. And the answer is D. Okay, and just to answer Allison's question, the principal is the party of which you are signing the contract with. Okay, moving right along. For example, you could have a client who wants to buy a house. You're showing them homes, but you haven't necessarily signed anything with them. They're just somebody you're working with. People use the word client a little more liberally. In a real estate transaction, fiduciary duties are owed to the A, customer, B, agent, C, principal, and D, broker. So we did this one before, so I hope you guys get this quickly. Looks like you all are. Great. And I asked this in the beginning of the webinar today. I'm going to ask it again because it's super important. What are the essentials of an agency relationship? What are the essentials of an agency relationship? I told you that acronym ACOLD, ACOLD. What do you guys think? So it's accountability, confidentiality, obedience, loyalty, and disclosure. All right, good job. A real estate licensee is usually presumed to be the agent of the A, buyer, B, party with whom a contract has been signed, C, owner of the real estate, or D, party paying the commission. Okay. And the answer is party with whom a written contract has been signed, which would make them the principal. Don't worry about answering the longer answer. I did it all the time myself, but that could get you in trouble. But I got to be honest, it happens a lot. When you see the long, complicated answers, very often they're correct. If a salesperson acts as an independent contractor, then A, all of his listings belong to him. B, he controls his own power. C, collects from his commission checks. D, he is responsible to his broker as to how his work is performed. The answer is B. He controls his own working hours. We'll answer D. He is responsible to his broker as to how his work is performed. He is not. When you're an independent contractor working for a real estate firm like Keller Williams, Coldwell Banker, or Remax, it's just about results and making sure you don't violate the law or legally jeopardize the company. That's what the broker is basically there for, to make sure you don't jeopardize the integrity of the company. Okay? And for doing that, they take a percentage of your commission. So they oversee things. When they oversee the work, that's more for a salary person. Okay? When they have specific ways the work is done. When you're an independent contractor, it's the results. You don't have them, you're not with us anymore. If you do have them, great, keep on moving. A seller has listed her home with a broker for $90,000, and the broker tells a prospective buyer to submit a low offer because the seller is desperate to sell. The buyer offers $85,000, and the seller accepts it. In this situation, A, any broker is authorized to encourage such bids from the property. B, the broker was unethical, but the seller did get to sell her property. C, the broker acted properly to obtain a quick offer on the property. Or D, the broker has violated his agency relationship with the seller. Okay, the answer here is D. Unfortunately, you see this all the time in real estate, and it's a terrible thing. A seller tells a broker in confidence, saying, hey, you know what, I really need to sell. I want $100,000, but I'll take $90,000 if you see it. Then the broker goes to the buyer who just wants a quick sale and says, they'll take $90,000, just submit the offer. And of course, that violates the confidentiality. How do you know if it violates the confidentiality? There's a real easy way to know. Can you tell the seller what you did and be okay with it? Right? And I don't believe that you could tell the seller saying, hey, you told me you'd take 90, so I told them that you would take 90. Right? That would make the seller very angry. It's a very easy way to tell if you violated fiduciary duty. If you're going behind their back and doing things that you know they would not be okay with, that's a violation. Because in that situation, the seller is just saying, I'll take 90 grand if you see it, but do not publicize that and do not seek that. Okay, moving right along. Which of the following is a requirement for a valid agency relationship? A, compensation. B, brokerage license. C, written agreement. Or D, mutual consent. Okay, good. D, mutual consent. Okay, remember a cold. All right, here we go. Which of the following would not terminate an agency relationship? Expiration, performance, termination, renewal. What do you guys think? Which of the following would not terminate an agency relationship? Expiration, performance, termination, or renewal? Okay, so the answer here would be renewal, because that obviously means you keep the relationship going. All the rest of them, termination is the word terminate, expiration means no longer there, and performance means you completed what was asked of you. Which of the following listings is illegal in most states and open to fraudulent dealings? A, a net listing, B, an exclusive agency, C, an open listing, or D, an exclusive right to sell? Okay, and the answer here is A, net listing. It's not illegal in all states, but it is illegal in most states because there's a conflict of interest there. And here's why. If you want to sell a property for 500 grand, okay, and I say, well, I'll keep anything above that 500 grand. Well, what happens if an offer comes in for 500 grand? I don't want to show it to you because I'll get nothing. I'll get screwed. I'll do all that work and I'll get no money. So there's a conflict of interest because you just want the 500 grand. And if an offer comes in for 500 grand, I don't have any incentive to bring it to you. And it puts me in a really tough spot. Do I make no money or do I do what's right and give you the property, give you the offer? Technically, I should give the offer, but it creates that conflict of interest. And therefore, most states just straight up say it's not legal. When an agency relationship ends, which of the following duties does not continue? A, loyalty, B, confidentiality, C, accounting for money, or D, accounting for property? Good. We went over this one before, so I hope all you guys got it right. A, loyalty. Nice job. A real estate licensee is usually presumed to be the agent of the A, party paying the commission, B, the buyer, C, owner of the real estate, or D, party with whom a written contract has been signed. Okay, good. The answer here is D. When negotiating a lease on behalf of a commercial real property landlord, the broker would usually calculate his commission as A percent of the first and last month's rent, B, a percent of the rent due in the first year of the lease, C, a percent of the rent due for the entire lease period, or D, a percent of the rent due for the first 6 months of the lease. What do you guys think? Okay, so typically it's percent due of the entire lease period. Okay, now I want you to look at, it says usually here. So some of you guys may have examples where you get paid in other manners. Remember, you can get paid whatever is agreed upon. Usually, it's a percent of the entire lease period. The maximum commission a broker may charge for the sale of residential property is 6% of the total sales price of a residence, set forth in real estate law, determined by the broker's contract with his principal, or determined by local custom. And the answer is C. I feel like I'm monitoring a game show. Do you guys think I'd be a good game show host? I feel like this is game show host training. Okay, next question. Okay, a real estate licensee has a buyer agency agreement. What is the seller in this situation? A, an agent, B, a fiduciary, C, a customer, D, a client. Okay, and the answer is C, a customer. So remember, the agency relationship is with the buyer, not with the seller. A broker has been in business for many years. He currently has 40 exclusive listings in his office. The broker dies, and his daughter, who is also a broker, takes over for him. What should she do about the current listings? A, she need only inform the Bureau of Real Estate that she is now the broker of record. B, do nothing. C, she must attempt to renegotiate all the listings. Or D, just inform the seller that she is taking over as broker. What do you guys think? And the answer is C, because you guys have to remember this is a personal service contract, meaning they sign a listing with a person, not a company. So when that person is not there, everything must be renegotiated. The main obligation of the principal owes a real estate agent is A, confidentiality, B, compensation, C, obedience, and D, accounting. Okay, and the answer here is B. The principal owes you money or whatever you agreed on. You owe the principal confidentiality, obedience, and accounting. But the main thing the principal owes you is money. They're not the licensed party, so you cannot expect them to have license obligations like confidentiality, obedience, and accounting. Okay? They just owe you money or whatever you agree upon. Jones agrees to represent Brown in the sale of a property. The listing contract states that Jones will receive a fee of $25,000 from Brown at closing. Regardless of the sales price, is this a valid form of compensation? A, yes, compensation can be determined in any number of ways as long as the seller and the broker agree. B, yes, the broker is supposed to charge what the traffic will bear. C, no, the seller should pay on the basis of stated percentage on contract price. Or D, no, a flat fee exposes the seller being cheated. Okay, seems like all you guys got this one right pretty quickly. The answer is A. Good job, everybody. We got 3 more questions to do today. Jones lists his house and tells the listing agent Brown, I'm listing it for $48,000, but I might take less. Brown may properly A, keep the information to himself, B, advertise the property for $40,000 or less, C, share Jones' statement only with the buyer's broker, or D, explain Jones' position to prospective buyers in an effort to obtain an offer. And we went over this before in another question that asked a similar concept. And that's what I explained to you. You got to put yourself in the seller's shoes. Is this something you could tell the seller you're doing? If so, go for it. If you can't tell them, then you probably shouldn't be doing it. Isn't that what our mothers always taught us? That if you can't tell everybody what you're doing, then you probably shouldn't be doing it in the first place. So if you want to be a good real estate agent, just follow what your mother told you. Okay, which of the following is a requirement for a valid agency relationship? A, written agreement. B, mutual consent. C, brokerage license. D, compensation. And the answer is B. Good job, everybody. Okay, last one of the day. Here we go. When negotiating a lease on behalf of a commercial real estate property landlord, the broker would usually calculate his commission as A, a percentage of the rent due in the first year of the lease, B, a percentage of the first and last month's rent, C, a percentage of the rent due for the first 6 months of the lease, D, a percentage of the rent due for the entire lease period. And the answer is D. Good. So we went over a bunch of questions. Some of these questions went over more than once because I wanted to drive home certain concepts, but we did a good job today. I will be back on Monday with another webinar. I hope you guys join in. And I'm also going to try and do things in different ways. I may try like a word cloud, a quick flash vocabulary review. But now we've been doing these webinars for a little bit, and we might try some different things to kind of spice it up and give everybody different ways to learn. So that's it for today. And I hope to see you guys on Monday. Also, remember to post these questions, all right, on our group, the PrepAgent Real Estate Exam Study Group. If you have any questions, I'll try and answer them there. I see a question. Are you able to go over listing agent and seller agent? So next week, we're going to do contracts and we're going to do listings. We'll go over that a lot. Okay, so with that being said, I see you guys on Monday. Talk to you guys soon. Oh, real quick, Samantha, you just wrote a question for me. Do you have any tips to remember the concepts besides flashcards? Yes, I do. It's really important that you print out our vocabulary worksheet. Okay, that's an empty worksheet. The reason we did that is so you guys physically write in the concepts. Writing stuff in helps you remember. It's a physical activity that prevents you from zoning out. And you write in 1 or 2 words. I don't need you writing big definitions. It's not a test in grammar or penmanship or typemanship. I don't know what the word is for typing. But that practice of writing the words in will help you remember those concepts. Okay, so I really emphasize active form learning rather than just having words flash in front of your face and you just zone out. So that would be my tip for remembering concepts besides flashcards. All right. With that being said, now signing off, and I'll see you guys on Monday. Thanks for coming, everybody. Talk to you guys soon.